Good morning. Let's go ahead and call to order the Committee on Professional Conduct this morning. To start off, I'm going to do a roll call. Board members can state their name, and we'll start over here.
Mark Silverman. Larry Kaplan.
Sunny Youngson Park.
Michael Savoy.
George Family.
Jose Campos.
Okay, we have established a quorum. So our first order of business this morning is the approval of the minutes of our January 26, 2017 meeting. Can I have a member who would like to make a motion?
So moved.
I'll second.
Okay. Any additional comments? Any comments from the public? I will now call for a vote.
Okay, George Camelot,
Yes?
Jose Campos,
Yes.
Larry Kaplan,
Yes.
Sunny Youngson Park,
Yes.
Michael Savoy,
Yes.
and Mark Silverman.
Yes.
Okay. Our second order of business, you're going to have Cindy Fuller discussing rulemaking items in the continuing education area.
Good morning. The purpose of this agenda item is to provide an opportunity for the California Board of Accountancy to consider taking action to approve the proposed language for CBA regulations sections 88, 88.1, 88.2, and 89. This will institute two new delivery methods, nano learning and blended learning, and allow continuing education, or CE, hours to be earned in 1/5 increments. Attachment 1 to this item is a statement on standards for continuing professional education programs, which I will be referring to as the standards. And attachment 2 is the proposed amendments to CBA regulations identified by underline and strikeout. The CBA has been very active in its discussion on the changes in the standards since May of 2015, when the exposure draft was first released. The standards became effective September 1 of 2016, and at the November of 2016 meeting, the CBA directed staff to draft regulatory language to amend CBA regulations. 4 sections of the regulations have been identified that require amendment. You may wish to return to attachment 2 as I highlight each section. I will pause after each section and turn it back over to the chair for comments. First, section 88, program which qualified. The proposed language begins on page 2 of attachment 2. It establishes and defines nano learning and blended learning and the requirements necessary to qualify as a CE program. These requirements are consistent with the requirements of other CBA-approved delivery methods. Also, near the middle of the page, subsection F3 states for a nano learning program, CE credit is not awarded for the ethics, fraud, or regulatory review requirements as defined in CBA regulations. I would like to turn it over to the chair for any comments or questions.
I have no questions. Any questions from other board members? Okay.
Next is section 88.1, provider requirements. The proposed language begins on page 5. This section establishes and defines requirements for providers who offer nano learning and blended learning programs. These requirements include record retention, schedule of course materials, and certificates of completion. These requirements are consistent with the requirements of other CBA-approved provider requirements. I would like to turn it over to the chair for any comments or questions.
No questions? Any questions from any board members? Okay. Proceed.
The third affected section is 88.2, program measurements, which begins on page 7. The proposed language allows CE credit to be awarded in 1/5 increments for all current delivery methods once the initial CE credit is earned. This language is found on page 7 and 8. The bottom of page 8 and page 9 establishes and defines nano-learning and blended learning program measurement requirements. This includes the amount of credit and specific timeframes, the minimum passing score for completion, and the delivery method requirements. I would like to point out at the bottom of page 8, under D, nano-learning, it references section 88F. 88F, as I mentioned earlier, does not allow CE credit to be awarded for the ethics, fraud, or regulatory review requirements. I would like to direct you now to the bottom of page 9 under C3. Due to the fact that a nano-learning segment may be incorporated into a blended learning program, section 88F3 has been referenced to ensure ethics, fraud, and regulatory review are not acceptable for the nano-learning segment. These requirements are consistent with the requirements of other CBA-approved program measurements. I would like to turn it over to the chair for any comments or questions.
I have no questions. Any other questions, board members? Okay.
The final section I will be discussing is section 89, control and reporting, which begins on page 10. Near the top of page 10, language has been included to incorporate the 2 new learning programs. On page 11, the language establishes and defines requirements for retention and documentation for nano-learning and blended learning programs. This language is consistent with other CBA-approved control and reporting requirements. I would like to now turn it over to the chair for discussion on the final section, and if the CBA supports the proposed regulatory language for CBA regulation sections 88, 88.1, 88.2, and 89, staff recommend that the CBA make a motion to approve the proposed regulatory text in Title 16, CCR sections 88, 88.1, 88.2, and 89, and direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business and Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing. Thank you.
Okay. I had no questions on section 89. I think we'll open it up. Other board members, anything specific to section 89? Okay. Discussion, open up to the board members.
I move to approve the recommendation as laid out just previously and as laid out on page 3 of the memorandum that accompanied the rulemaking information.
Okay. Do we have a second?
I'll second.
Any comments, any additional comments from any board members? Any comments from the public? We'll now call for a vote.
Mark Silverman,
Yes.
Michael Savoy,
Yes.
Sunny Youngsung Park,
Yes.
Larry Kaplan,
Yes.
Jose Campos,
Yes.
and George Familet.
Yes. Okay, moving on. I'm going to have Ms. Pierce come up and give us a presentation in terms of how information is collected.
Agenda item 3 is an overview of the current laws that provide for the protection of electronically collected, transmitted, or stored confidential client information. As members may recall, at the January meeting, a discussion was held on the sale or transfer of a licensee's practice and client notification of discontinuance of a licensee's practice. During that discussion, it was requested that the topic of protecting electronically collected, transmitted, or stored confidential client information be placed on a future CBA agenda. In consultation with DCA Legal Counsel, it was determined that both Business and Professions Code Section 5063.3 and CBA Regulation Section 54.1 contain a provision that does not allow for a client's information to be disclosed without the written permission of the clients, except under specific exceptions. This protection exists regardless of whether the information is in hard copy or electronic format, and addresses client information during collection, transmittal, and storage. In addition, AICPA published guidance for licensees as it relates to data security and ensuring information is maintained in a confidential manner. There's no recommendation on this item. It was just to provide clarification as it relates to protecting client information.
So I guess I'll start off with comments. I think this came up in the context of our last meeting, if I remember correctly. In the sale of a business, there was a question by another board member who's not here right now about what happens to the information. If I'm following this correctly, there are rules already in place to manage that, is my understanding.
I think the question from the last meeting was whether there was a requirement for encryption and specific requirements for transmitting things electronically in our law. And there is no such requirement, but there's a general requirement both in the statutes and the reg mentioned by Ms. Pierce, and also the general standards for ethics by the standard setting body. And since you enforce those general standards, I think any breach would be analyzed on a case-by-case basis to see if they took reasonable steps under the circumstances to secure that information and keep it safe from disclosure, because it's all about whether you kept it confidential, and it's not if you didn't take reasonable steps and someone was able to breach your security. And that's kind of the way that we would look at it. I think that that's typical for professions regulated by the state, that you have a general standard, then you look at the facts to see if the steps were taken that were reasonable under the circumstances.
Okay. Questions from other committee members? Okay. It looks like we don't have I think this was a clarification, we don't have a recommended action, so I think we can move on to the next item. Any comments from the public before we move on? Okay. We're going to move on to the next item. And we're going to have Cindy back up, and we're going to discuss some model rules.
Thank you. This agenda item provides the CBA an opportunity to review and discuss the NASBA exposure draft regarding proposed changes to the model rules for continuing professional education. Going forward, I will refer to these as the rules and have been provided as attachment 1. The CBA will be asked to determine if the proposed comment letter should be submitted on behalf of the CBA prior to the conclusion of the comment period on June 30th, 2017. The proposed comment letter is provided as attachment 2. The Statement on Standards for Continuing Professional Education, which I will refer to as the standards, were revised in September 2016. While the standards are directed to course providers, the rules are directed towards licensees. These revised rules work in conjunction with the standards and act as guidelines for state boards of accountancy. As you will see in the rules, the revisions pertain to minimum annual continuing education, or CE, requirements. The revised rules are considerably more detailed and now clearly identify minimum annual CE requirements, as well as 2 new delivery methods for CE, nano learning and blended learning. The following is an overview of relevant changes made to 5 of the rules. On the bottom of page 1, Rules 3.8 discusses technical fields of study. Rules 3.8 was not previously defined and has been added to provide clarification of technical subjects that contribute to the competence of a CPA and that directly relate to the CPA's field of business. Accounting, governmental auditing, business law, economics, finance, information technology, management services, regulatory ethics, specialized knowledge, statistics, and taxes are identified as technical fields of study. In comparison to CBA regulations, business law, economics, management services, and statistics are not specifically identified in CBA regulations. Additionally, the rules identify ethics in 2 categories. Regulatory ethics is technical, and behavioral ethics is non-technical. On page 2, Rules 3.9 discusses the non-technical fields of study. Rules 3.9 is added to identify subjects that indirectly relate to the CPA's field of business and include behavioral ethics, business management and organization, communication and marketing, computer software and applications, personal development, personnel and human resources, and production. In comparison to CBA regulations, behavioral ethics, personal development, and production are not specifically identified. At the bottom of page 2, Rule 6.4 discusses CE requirements for license renewal. Rule 6.4a has been revised to require an average of 2 hours of ethics CE in each year of the reporting period. In comparison, CBA regulations require a licensee renewing in an active status to complete 4 hours of ethics education as part of the required 80 hours of CE, and these hours can be taken anytime within the reporting period. Rule 6.4b has been expanded to include CE requirement details for first-time licensees. New licensees are required to complete a minimum of 40 hours of CE during the first full annual period following the year in which the original certificate, registration, or license was issued. In comparison, CBA regulations requires a new licensee to complete a minimum of 20 hours of CE for each full 6-month period from the date the initial license was issued to the first license expiration date. On page 4, Rule 6.5 discusses the various delivery methods. Rule 6.5a did not previously identify and now has been revised to identify learning activities and delivery methods. CBA regulations define and address specific delivery methods which qualify as acceptable CE, but do not include nano learning and blended learning. Under Agenda Item 8A2, proposed regulatory language is being presented to address these 2 delivery methods. On page 6, Rule 6.6 discusses program measurements for CE credit. Rule 6.6a has been revised to provide computation program measurements for all delivery methods and learning activities, and also specifies that CE credit can be earned in 1/5 increments after the first full credit has been earned for specified delivery methods. In relation to Rule 6.6a, CBA regulations require CE credit be granted in 50-minute or 1-hour increments, with the exception of self-study programs, which may be claimed in 25-minute or 1/2-hour increments. Under Agenda Item 8A2, proposed regulatory language is being presented to allow CE credit to be earned in 1/5 increments after the first full credit has been earned. Additionally, Rule 6.6a1f and Rule 6.6a1g specify that the maximum credit allowed for technical review of CE programs and writing published articles, books, and other publications cannot exceed 50% of the total CE hours required for the reporting period. In comparison, CBA regulations specify the maximum credit allowed shall not exceed 25% of the CE required for the renewal period. Staff have no recommendation on this item. However, should members wish to comment on the rules, staff recommend approval of the attached comment letter. Should the CBA wish to make any revisions to the letter, it may wish to delegate authority to the CBA president to approve the final letter. It is important to note that members will be afforded the opportunity to review and consider which changes may be appropriate to incorporate into CBA regulations upon release of the final version of the rules. At this time, I would like to turn it back over to the chair.
Okay, thank you. Any questions from committee members? Yes.
If none of the members have anything, okay. So if you look at page 3 at the top, one of the items that Ms. Fuller mentioned was what I think we call a new 50-50 requirement. So currently, under your current standards for ethics, the 4 hours can be earned anytime during the 2-year renewal period. this type of proposal, if it came back to you for consideration at some point, would state that you have to have 2 hours in the first year and 2 hours in the second year. So one of the things you might want to ask is why that is being proposed, because if it comes back to you for a potential consideration to incorporate into your standards, you have to have a good reason for imposing a stricter requirement on the licensing population. And in light of the most recent North Carolina Supreme Court decision, I think that you'd want to explore that before maybe considering that on a policy level. So that might be something you want to add to the letter, just a request for clarification regarding why this requirement is necessary.
In terms of motion, do we want to consider a motion to submit the letter and delegating the authority to the executive officer to make additional suggestions in the letter?
Yeah, I personally didn't think we needed a letter. I mean, I think it's pretty well understood that any new guidance that comes out is going to require some regulatory considerations. I think the point you bring up is a good one, but it seems a little sort of specific to one piece of this, and I think there'd be opportunities to gather additional fact-finding on, you know, why they propose whatever piece of this that we decide to incorporate. And so rather than picking and choosing one, I'm fine with the attachment 2 that basically informs them we've got a process, but I'm sure all other 53 jurisdictions have the same thing,
Okay.
right? And so those were my thoughts.
Okay. Do we have a motion?
I don't have a motion. Sounds like we don't need a motion.
Yeah, I know. Okay. All right. Okay, any public comments? Okay. Agenda items for next meeting, we'll make note of that. Okay. Unless there's other comments, I think the committee is adjourned.